Good evening, everyone. And when we have Justice K.T. Sankaran, a former judge of Kerala High Court and a former member of the Law Commission, you are quite sure that his explanations to the things are such that which are received well with everyone. And after his sessions on different aspects of Limitation Act and CPC, we thought that since we are celebrating 75 years of Constitution of India, let's discuss about the human rights contemplated under the Constitution of India and the legal journey. We are thankful that Sir has accepted our invite. And over to you, sir.
Yes, thank you, Mr. Vikas. Good evening, everybody. Now, our subject is human rights and constitution. First of all, I think it is audible to all of you. Is it audible? Yes. What is human right? There are several literature on that. Several authors have written several things. And there is a definition under the Human Rights Act. And the law has developed throughout the years. And now we have reached a stage where almost all activities where human dignity is involved, it is a human right. Human beings are born equal in dignity and rights. Unlike the other lectures on CPC and Limitation Act, to some extent I am using extempore speech, and to some extent I will read because it is some literature. Therefore, I cannot by heart say all those things. Human beings are born equal in dignity and rights. These are normal claims which are inalienable and inherent in all individuals by virtue of their humanity alone, irrespective of caste, color, creed, and place of birth, sex, cultural difference, or any other consideration. These claims are articulated and formulated in what is today known as human rights. Human rights are sometimes referred to as fundamental rights, basic rights, inherent rights, natural rights, and birthrights. Please note this. Human rights are sometimes referred to as fundamental rights, basic rights, inherent rights, natural rights, and birthrights. The state maintains the framework of social order by implementation of various laws without which well-ordered social life would not be possible. Now, let us see the various aspects of human rights. Protection of Human Rights Act 1993 defines human rights in section 2D. 2D. If you have got a book, please look into it, otherwise here. 2D. Human rights means the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. So it is fundamental rights plus the principles embodied in the international covenants, individual rights guaranteed in international covenants, enforceable by courts in India. There are several documents, right from Magna Carta to recent laws, covenants, and treaties, which reiterate the various aspects of human law. I will just read the heading Universal Declaration of Human Rights, 1948. Mainly, then natural rights theory, landmark development, Magna Carta 1215. What is Magna Carta? The king was compelled to sign a document which is called Magna Carta, recognizing the rights of individuals, their dignity in their life, and all those things. That is what is called Magna Carta in 1215. Great Charter of 1250, most significant constitutional document of all human history. The English Bill of Rights 1689, American Declaration of Independence 1776, Declaration of International Rights of Man 1929, UN Charter 1945. The Universal Declaration of Human Rights 1948 is a basic document, one of the important documents, was not legally binding document. And therefore, in 1966, two covenants came into existence. They are International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights. Now, human rights in ancient India, unlike the modern focus on individual entitlements, ancient Indian thought, uh, Indian thought emphasized duties of individuals and rulers, which in turn guaranteed the well-being of others. Manusmriti, Yajnavalkya Smriti, and other Dharma Shastras prescribed the duties of for different members of society, including kings, householders, and ascetics. These duties indirectly ensured the protection of life, dignity, and property. Rigveda contains hymns and emphasizes unity and equal worth of all human beings. No one is superior, no one is inferior. All are brothers marching toward unison. This is what Rigveda said. So this theory was embedded in our Dharma Shastras. Several years ago, we had recognized these human rights. It is coupled with the duties of citizen towards the country. And now our constitution also fundamental rights are there, fundamental duties are also there. Then directive principles of state policy, all those things. We will come to that later. And post 1950s, emergency was there, recognition of women's right as human rights became international law when UN General Assembly adopted the Convention on Elimination of All Forms of Discrimination Against Women in 1979. With reference to India, the Indian Constitution prohibits discrimination on the basis of sex. It also recognizes that women need special attention. Article 2342 mainly. Then there are other acts, Protection of Women from Domestic Violence Act, etc. There are various statutes recognizing human rights. Articles 14, 15, 16, and 39 guarantee equality among sexes. Children of our country are most underprivileged in our society. Various laws were evolved to protect their rights and to afford human dignity to them, to protect their human dignity. Child labor, the Prohibition of Child Marriages Act, Child Labor Prohibition and Regulation Act 1986, Child and Adolescents Labor Prohibition and Regulation Act 1986, Minimum Wages Act 1948, Factories Act 1951, Plantation Labor Act 1951, Indian Factories Act and Mines Act 1952, the Merchant Shipping Act, Apprentices Act, Atomic Energy Act, BD and Cigar Workers Condition of Employment Act, Shops and Commercial Establishments Act. 1986 law is the most important one, wherein the Act lists occupations and processes in which employment of children is prohibited. Now, various constitutional provisions, I will just lay emphasis on the important things. Article 17 abolishes untouchability and declares it is punishable by law. Since the age-old custom continued even after independence, the parliament made more stringent law in 1989 by Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act. Article 15(4) permits the state to make special provisions for the advancement of scheduled castes, scheduled tribes, and other backward classes in educational and technical institutions, notwithstanding anything contained in Article 15 or Clause 2 of Article 29. Reservations in public services made under Article 16(4) for backward classes. Special laws are made to protect the tribal land, which forbids the sale or transfer to non-tribals. These are some of the laws. Constitutional framework we will see. In short, see, we can divide this into the following part 3. Part 3 of the Constitution, the following subdivisions. Right to fundamental rights are the following. Right to equality, please note. Right to equality, Articles 14 to 18. Right to freedom, Articles 19 to 22. Right against exploitation, Articles 23 and 24. Right to freedom of religion, Article 25 to 28. Cultural and educational rights, Article 29 and 30. Right to constitutional remedies, Article 32 and Article 226. Now let us have a bird's eye view of the various articles. 14. Equality before law. It states that equality, the state shall not deny any person equality before law or the equal protection of the laws within the territory of India. 15. Prohibition of discrimination on the grounds of religion, race, caste, sex, or place of birth. 16. Article 16. Equality of opportunity in matters of public employment. 17. Abolition of untouchability. 18. Abolition of titles. 19. Protection of certain rights regarding freedom of speech. What are they? Freedom of speech and expression, which are very valuable rights. To assemble peaceably and without arms. To form associations or unions or cooperative societies. To move freely throughout the territory of India. To reside and settle in any part of the territory of India. To practice any profession or to carry on any occupation, trade, or business. Then Article 20, protection in respect of conviction for offences. No one shall be convicted twice for the same offence. He shall not be punished for, he shall not be imprisoned for a term which was not prescribed under the law then in existence, etc. etc. Article 21, protection of life and personal liberty. Very important article. No person shall be deprived of his life or personal liberty except according to the procedure established by law. What is procedure established by law? Various decisions developed in the Supreme Court of India and various high courts. Article 21A, right to education. Article 22, protection against arrest and detention in certain cases. 23, prohibition traffic in human beings and forced labor. 24, prohibition of employment in children in factories, etc. 25, freedom of conscience and free profession, practice and propagation of religion. 26, freedom to manage religious affairs. 27, freedom as to payment of taxes for promotion of any particular religion. 28, freedom as to attendance at religious instruction or religious worship in certain educational institutions. 29, protection of interest of minorities. 30, right of minorities to establish and administer educational institutions. 32, remedies for enforcement of conferred by Part 3. These are mainly the fundamental rights, where in various aspects of human rights are involved. Apart from the Protection of Human Rights Act, these rights are enshrined in our Constitution, and even before the Constitution, various Dharmashastras and our Puranas, it is our various scriptures, these rights are recognized. And the duties are also shown. A right without duty is meaningless. There must be a right. Our constitution also says that there must be fundamental duty and fundamental right. But importance is given to individual rights rather than duty. We forget about the duties, but we speak of only of our rights. Then direct part 4. Fundamental rights are in part 3. Part 4 of our constitution provides for directive principles of state policy. It says, part 4, application of the principles contained in this part. Article 37 says, the provisions contained in this part shall not be enforceable by any court, but the principles therein herein laid down are nevertheless fundamental in the governance of country, and it shall be the duty of state to apply these principles in making laws. And when we go through the various provisions and fundamental the directive principles, we can see that the state has made various laws, various hundreds of laws to protect the rights of men and women. And though non-justiciable, these directive principles provide for equal pay for equal work, education and public health, protection of children and workers, environmental protection. Article 38. State to secure a social order for the promotion of welfare of the people. Article 39 provides, among others, that the citizens, men and women, equally have the right to an adequate means of livelihood, that there is equal pay for equal work, and the health and strength of workers, men and women, and the tender age of children are not abused, and that children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. Article 39A, equal justice for and free legal aid. These are all Article 39, various laws are there. Likewise, Article 39A, equal justice and free legal aid. Provisions are there in the CRPC, now BNSS, for legal aid. Article 40, organization of village panchayats. The constitution itself recognizes village panchayats. Article 41, right to work. Panchayati Raj institutions, various provisions are made in the constitution. Reservation for women in the Panchayati Raj institutions, etc. etc. Article 41, right to work, to education and to public assistance in certain cases. Article 42, provision for just and humane conditions of work and maternity relief. Article 43, living wage, etc. for workers. Article 43A, participation of workers in the management of industries. Article 43B, promotion of cooperative societies. Article 44, uniform civil code for citizens. Recently, yesterday, day before yesterday, the Delhi High Court said about the uniform civil code, why it is time for framing uniform civil code, etc. The Delhi High Court said. Article 45, provision for early childhood care and education of children below the age of 6 years. Article 46, promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections. 47, duty of the state to raise the level of nutrition and the standard of living and to improve public health. Article 48, organization of agricultural and animal husbandry. Article 48A, protection and improvement of environment and safeguarding forest and wildlife. How many laws are made under this? Wildlife Protection Act, Forest Preservation Act. So many acts, so many. And these are various laws are made, punishments are provided, offences are provided, etc. Protection of monuments and place of objects of national importance. Article 50, separation of judiciary from executive. Article 51, promotion of international peace and security. These are mainly the provisions in the Constitution which aims at protection of human rights in various aspects of human life. The dignity of human life, dignity of human beings are protected in various provisions. How far practically they are available is a matter of concern for all of us. Even though we got independence several years ago, why these things have not reached the lower level is a matter of concern. There are several aspects: education, poverty, lack of education, poverty, and various other cultural and other aspects affecting the human beings. And therefore, India is a very vast country having 142 crores of people. We cannot compare with a small state, small country where the uh, population is less than a state of ours. For example, uh, the United States has one third of our population. And what about the developed country like Israel? The population is less than that of Kerala. Australia, it's a bigger country, very vast country. It's a subcontinent. It is a continent. Still, what is the population? Less than that of a state, UP. So resources are there. Area of cultivable land is excess. And various aspects are there. Therefore, we cannot compare, but at the same time, we are striving hard to protect the human rights, to protect the living conditions of human beings in India at various levels throughout the years. Now, human rights institutions are there. The Protection of Human Rights 1993, the Statement of Objects and Reasons says, very interesting. India is a party to the International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights, adopted by the UN by the General Assembly of the United States on the 16th December 1966. The human rights embodied in the aforesaid covenants stand substantially protected by the Constitution. However, there has been growing concern in the country and abroad about issues relating to human rights. Having regard to this, changing social realities and emerging trends in the nature and crime and violence, government has been reviewing the existing laws, procedures, and system of administration of justice with a view to bringing about greater accountability and transparency in them and devising efficient and effective methods of dealing with the situation. Then various authorities are there. National Human Rights Commission is there. State Human Rights Commissions are there. Human Rights Courts are there. And various powers are given, recommendatory powers are given. And mainly Section 12, functions of the Commission. The word Commission is defined as National Commission. And the State Commission is referred to as a State Commission. There. Various provisions are there for providing for legal proceedings and the procedure to be followed and reports to be filed, how, what are the powers of the tribunals or commissions and all those things. We are not going into all those things. Functions of the commission, just have a glance at them, section 12. The commission shall perform all or any of the following functions, namely, inquire into suo motu or on a petition presented to it by a victim or any person on his behalf or on a direction or order of any court into the complaints of, there are two aspects, complaints of violation of human rights or abetment thereof or negligence in the prevention of such violation by a public servant. These are the two aspects they will inquire into. For which powers are there, which contain from clause B onwards, intervene in any proceeding, visit any institution, jail, etc., review the safeguards provided under the Constitution, review the factors including act of terrorism that inhibit the employment enjoyment of human rights, and recommend appropriate remedial measures, study of treaties, undertake and promote research, spread human rights literacy among various sections of the society, encourage the efforts of non-governmental organizations and institutions, such other functions as it may concern itself. The various procedures are also provided. I am not going into the Human Rights Act because that is not our subject. Human rights, we know what it is, and human rights are how protected under our constitution is our subject. Various international covenants and treaties are there which are binding on us and binding on the courts. And there is another interesting aspect. Fundamental duties are there. Please see 51A of the Constitution. 51A clause G, to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. This is one aspect of fundamental duty of a citizen. Now, in the this part 4A fundamental duties, there is a separate chapter, only one article in 51E, that is 51E. In the directive principles of state policy, there is a provision like order, say, Article 48A, which provides Article 48A was inserted by the Constitutional Amendment Act 1976. Apart from the fundamental duty, it has been incorporated in the directive principles of state policy so that the state can enact laws, and it is a rule of governance. The state shall endeavour to protect and improve the environment and to safeguard the forest and wildlife of the country. It is not only a fundamental duty, it is a duty of the state also to make laws for it. You cannot enforce it through a court of law, but at the same time, it is a rule of governance. The state is bound by it. And it is not only the citizens' duty, but it is also state's duty to provide for the mechanism for protection of wildlife, protection of environment. And of late, we realized, the world over, realized that protection of environment and all other things are required for uh, protecting child and protecting climate change, etc., and affecting the human beings in various factors. Now, we will look into some of the reported decisions, some of the decided cases, some of the decided cases. Various provisions of Human Rights Act, we are not going into it because for the reasons stated. On 2021, NHRC, that is Human Rights Commission, issued an advisory upholding the direct dignity and protecting the rights of dead in the COVID time. What happened? In the light of unprecedented COVID deaths in India, there is no specific legislation for protecting the rights of dead in India, probably because no need was felt in the light of societal conventions and mores. However, during COVID-19 related deaths and the consequent explosion in mortality figures in India, there was media reports of unclaimed, unaccounted, and unidentified dead bodies found floating in rivers. The advisory ensured that even in case of COVID-19 related deaths, the human dignity of the dead is observed, because it is not only a right of the human being who is living, Even after death, he has got certain rights. Judicial interpretation, activism, some of the precedents. One is Keshavananda Bharati versus State of Kerala. It is not regarding human rights or of the court. AIR 1973 Supreme Court 1461 73 Supreme Court. Unlimited power of the Parliament to amend the Constitution subject to basic structure and doctrine. Maneka Gandhi, AIR 78 Supreme Court 597. Expanded Article 21 to include due process, dignity, and fairness. It was only a question of passport, issuing passport. And ultimately, nothing turned out, but the court expanded the Article 21 and interpreted Article 21. Husainara Khatun versus State of Bihar, AER 79 Supreme Court, AER 79 Supreme Court 1369. Detention of under trial prisoners without trial. Right to speedy trial is a fundamental right under Article 21, Supreme Court held. Husainara Khatun was a, if I remember correct, was a press woman, and she wanted early disposal of the case immediately. But the court was looking into various aspects. So she abandoned the case. If I remember correctly, this is the case. But the Supreme Court did not leave it there. Supreme Court considered it on the considered the various aspects and issued directions and interpreted Article 21. Speedy trial is a fundamental right. Then People's Union for Democratic Rights, AIR 1982 Supreme Court 1473. Exploitation of workers during Asian Games was the subject. Forced labor violates Article 23. Public interest litigation mainly focused on this decision. Sheila Barsey versus State of Maharashtra. AER 1983 Supreme Court 378. Ill treatment of women in custody was the subject. Then Olga Tellis versus Bombay Municipal Corporation. AER 1986 Supreme Court 180. Rights of payment dwellers not to be evicted. Recognized right of livelihood as part of Article 21. Humanized urban planning and eviction law. Dear friends, when I was in Delhi for 2 years, I saw the plight of several people who are pavement dwellers during scorching sun or biting winter. How they are living, how they are living. I found it very difficult to contain, but various parts of Delhi, because it is a thickly populated area, people come from other states and settle there, even in pavement, to see that they get some job. I am told, but such a sight we will not see in some of the southern states. I am not saying I am not differentiating because of various reasons. You may not get it in UP or Bihar, but in cities like Delhi is there, Bombay. But we have to see that those people have also human rights. It is our concern also. It's our concern. And the constitutional makers saw it. They provided various provisions. Courts are looking into it. Court is a watchdog of these human rights of these people. Whenever a case comes, they recommend they implement various provisions in an expansive manner, meaningful manner. Article 19 and 21 were interpreted in such a manner that every activity of human life which reflects on the human rights are protected. Ishaga versus State of Rajasthan, all of us know. AER 1997, Supreme Court 3011. Right of women's sexual harassment at workplace, there was no law, effective law. Therefore, the Supreme Court there found that there was a vacuum. But at the same time, the Supreme Court thought that to protect the human rights of individuals, sexual harassment against sexual harassment of women at the workplace, it is necessary to issue guidelines. It is called as Vishaga guidelines. Till a law is made, this shall be followed by all the courts and institutions. And later a law was made which provided for a scheme for all those things. And that is called Posh Act 2013. Sexual harassment of women at workplace within brackets Prevention, Prohibition and Redressal Act 2013. Posh Act. It is in short called Posh Act. Then another case, Neelabadi Bahara versus State of Orissa. AER 1993 Supreme Court 1960. Death in police custody. Compensation was granted to the victims. Then another case, People's Union for Civil Liberties versus Union of India, 2001, right to food. It was found by the Supreme Court even though food was plenty available, it was not distributed through properly. Some have, some are wasting, some are starving. So directed the state to ensure food access via PDS, Public Distribution System. Then famous Puttaswamy case. Privacy is a fundamental right. And Puttaswamy, reference was made to Golaknath, 1967 to SCR 762, Golaknath versus State of Punjab. There, it quoted with approval a paragraph in Golaknath. The learned judge emphasized the position of the fundamental rights thus. They are the rights of people preserved by our constitution. Fundamental rights are the modern name for what have been traditionally known as natural rights. As one author puts, they are moral rights, which every human being everywhere, all times, ought to have simply because of the fact that contradistinction with other things is rational and moral. They are the primordial rights necessary for the development of human personality. They are rights which enable a man to check out his own life in the manner he best likes. The fundamental rights, in other words, are primordial rights which have traditionally been regarded as natural rights. In that character, these rights are inseparable for human existence. Then, Puttaswamy's case in paragraph 150, 150. Reference is made to the cases where the rights have been held to flow from Article 21. Some of the human rights which flow from Article 21 has been categorized. I will read some of them. The right to go abroad. Satwant Singh, 1967 3 SCR 525. The right against solitary confinement. Sunil Batra, 1978 4 SCC 494. Next, the right of prisoners against bar fetters. Charles Sobaraj, 1978 4 SCC 104. Next is right to legal aid. M.H. Hoscott versus State of Maharashtra, 1978 3 SCC 544. Next, right to speedy trial. Husainara Khatun versus Home Secretary, 1980 1 SCC 1980 1 SCC 81. Next is the right against handcuffing. Prem Shankar Shukla's case, 1983 SCC 526. The right against next is the right against custodial violence. Sheila Barsay, 1983, 2 SCC. 1983, 2 SCC, 96. Next is right against public hanging. Attorney General of India versus Lesma Devi. 1989, Supplemental 1 SCC. 1989, Supplemental 1 SCC. 264. Next, right to doctor's assistants at government hospitals. Paramanand Katara versus Union of India. 1989 4 SCC. 89 4 SCC. 286. Right to shelter. Chandistar Builders versus so and so. 1991 SCC. 520. Right to healthy environment. Virender Gaur. 1995 2 SCC. 577. Next is right to compensation for unlawful arrest. Rudal Shah, Rudal Shah, 1983 4 SCC, 1983 4 SCC, 141. Right to freedom from torture. Sunil Batra, 1978 4 SCC, 494. Right to reputation. 2013 10 SCC, 2013 10 SCC, 591. Right to earn a livelihood. Olga Tellis. That is a payment dollars case. 1985 3 SCC 545. Now, when we come to environmental rights protection, etc., the famous case, MC Mehta's several cases. MC Mehta contributed much to the environmental protection. Likewise, from Kerala, Godavarman Tirumulpad case. Various orders were passed by the Supreme Court. Even recently, one order was passed. Privacy is a postulate of human dignity. Now, another case. Navtej Singh Johar. Now, independent cases. AIR 2018 Supreme Court 4321. Navtej Singh Johar. Constitutionality of Article 377 was considered. That we know what is that. Next is Joseph Shine versus Union of India. AER 2018 Supreme Court. 2018 Supreme Court 4898. Adultery law was held discriminatory 497 ITC. That is towards gender equality and personal autonomy. Paragraph 171 of that judgment. Next is Ranjit Singh versus Union of India 2024-25 run. That is that decision. I do not know the citation. A year and a page. Case Ranjit Singh. Environmental and climate changes. It was declared climate protection is part of right to life. 21 Article 21. Constitutionalized climate justice. Then next is Alok Singh versus Ayush Yardi. Alok Singh. Madhya Pradesh, 2025. Inclusion of disabled persons in judicial services. Alok Singh versus Ayush Yardi, YARDI. Then S. Rajashekaran versus Union of India. WPC 295 of 2012, decided in May 2025. Series of pointed observations were made that reflect both the legal urgency and human cost of inaccessibility. Right to have unobstructed and disabled friendly footpaths is guaranteed under Article 21. Even footpath, the right to have access and movement, is recognized under Article 21. The safety of pedestrians is not a luxury but a constitutional obligation of the state. The absence of accessible footpaths disproportionately affects persons with disabilities, older persons, and others who rely on mobility aids. Then next is M.K. Ranjit Singh and others. 2024 SCC Online SC 570. That is a right to be free from adverse effects of climate change. It is part of Article 21 and 14. That is human rights jurisprudence, environmental protection. Climate, it was held that climate impacts affect the dignity and health of marginalized communities. International jurisprudence referred to. Next is Arif Mohammad Yasin, 2025 INSC 785. Fake encounter in Assam. Supreme Court ordered the Assam Human Rights Commission to investigate 171 alleged police fake encounters from 2021 to 2023. Reaffirming the constitutional balance, the court underscored that procedural safeguards and right of victims and families be heard must not be overridden by generalized directions. Justice must be individualized. This is an aspect. Justice must be individualized, particularly where fundamental rights such as life and personal liberty are implicated. Court held that the role of human rights commissions, both the national and state levels, was paramount in a case of democratic polity governed by the rule of law. Next case, Just Rights for Children Alliance versus Harish. Just Rights for Children Alliance. 2024 INSC 716. POXO Act and IT Act strict liability for sexual exploitation and child abuse, child pornography, etc. Next is Umadevi versus Governor of Tamil Nadu, 2025 SCC Online SC 1204. We know one Umadevi old case where Justice Sadashivan decided on how, at what stage FIR should be registered. There should be compulsory registration of FIR, except in some cases where a preliminary inquiry is required, etc., etc. That is Umadevi's. No, I am sorry. That is another case. Umadevi's case is backdoor appointment, temporary appointment. Here, Article 21, Article 42, and Article 51 were considered. Grant of maternity leave to a woman. She had two children in the first marriage. She had a third delivery has to take place through second marriage. It was held by the government that she is not entitled to as per the government orders. Supreme Court struck that order and held that even there. Thus, it can be seen from the above through various international conventions. The world community has recognized the broad spectrum of reproductive rights, which includes maternity benefits. Maternity leave is integral to maternity benefits. Reproductive rights are now recognized as part of several intersecting domains of international human rights law, that is, right to health, right to privacy, right to equality, and non discrimination, and the right to dignity. So that was granted. 2025 INSC 677. Paul Yesudasan. Paul Yesudasan. Human rights. Refusal by a police officer to register an FIR and using objectionable language towards citizens constitutes a violation of human rights. A person goes to the police station, he makes a complaint, and the police does not register the case. The policeman does not register, the SHO does not register the case. He abuses. It is a human rights violation. The next, 2025 INSC 3. 2025 INSC 3. Bernard Francis Joseph. Right to property is considered to be not only a constitutional or statutory right but also a human right. It was a fundamental right, but it was removed from fundamental rights chapter. But it was a constitutional right or a statutory right, and the Supreme Court enhanced it and said that it is a human rights as well. 2024 SCC Online SC 230 Vedanta Limited versus State of Tamil Nadu. I'll read three sentences. It is an undeniable and fundamental truth that all persons have the right to breathe clean air, drink clean water, live a free life from diseases and sickness, and for those who till the earth have access to uncontaminated soil. These rights are not only recognized as essential components of human rights but are also enshrined in our various international treaties and agreements, such as the Universal Declaration of Human Rights, the Convention on Biological Diversity, and the Paris Agreement. Next is 2024 SCC Online SC86. TN Godavarman Tirumulpad. Clean environment is a human right. Then 2023 KSC Online 427 is a division bench of Kerala High Court, which refers to Yasita Sahu of the Supreme Court case. A child, especially a child of tender years, requires the love, affection, company, and protection of both the parents. It is not only a requirement of the child, but is basic human right. To be protected, to be looked after by the parents. Then 2022 SCC Online SC 704 Buddhadev Karmaskar relating to sex workers, rehabilitation, and other matters. It was held that it has to be noticed that the attitude of the police to sex workers is often brutal and violent. It is as if they are class whose rights are not recognized. The police and other law enforcement agencies should be sensitized to rights of sex workers who also enjoy all basic human rights and other rights guaranteed by the Constitution of India to citizens. And this is only a personal view. No Indian woman voluntarily goes for prostitution. She does not like to live as a prostitute or a sex worker. Circumstances make her. Either she was raped, sexually abused, or made homeless and exploited by others. She had no other go but to go for sex worker as a sex worker. She goes there not on her own volition, but because of the circumstances in which she is placed. It is we are responsible. We, the persons who criticize such people, are responsible. What will happen if all the sex workers are arrested and detained or they are driven away? from Delhi, Bombay, and other metros, what will happen? There will be chaos, is my personal view. Is my personal view. It is not a law or anything. Quite a personal view. I do not know whether you share that view with me. There will be chaos and unrest. So they are also doing service to the nation in their own way. We cannot brand them as sex workers as a heinous thing and all those things. We are responsible for making them like that. Next case is only a personal view, not a part of this lecture. 2021 1 SCC 2021 1 SCC 1 Amish Devgan hate speech. Dignity in the context of criminalization of speech with which we are concerned refers to a person's basic entitlement as a member of the society in good standing, his status as a social and equal and a bearer of human rights and constitutional entitlements. Paragraph 46 of that judgment. Next is AAR 2015 SC 2887 Dilip K. Basu. It issued directions. Supreme Court issued directions to install CCTV cameras in all police stations throughout the country. Made a lot of change. Lot of change. Even after that, there are places where the cameras, there are places where it is blind. There is places where the camera view will not be available. There they torture. But still, a lot of change has taken place throughout the country. That is by the court. Installation of CCTV cameras throughout India in all the police stations. And one of the old cases where human rights is recognized is a case, very interesting case. 1992, AER 1992, Supreme Court 392. Meera Mathur versus Life Insurance Corporation of India. Lady candidate passing examination found medically fit by doctor on panel. Alleged false declaration by her regarding last menstruation. There is a column in the as a hair hostess. I think. Post of assistant in Life Insurance Corporation. No. She applied for the post of assistant in Life Insurance Corporation of India. She was called for the written test. She passed. There is a column there. What is the date of your last menstruation? To see that she is not pregnant, the Supreme Court struck down this requirement was taken away. Then another case by Justice V.R. Krishna, very famous case, C.B. Muttamma versus Union of India. Sex discrimination. Provisions in the service rules requiring a female employee to obtain the permission of the government in writing before her marriage is solemnized and before her marriage is solemnized and denying right to be appointed on the ground that candidate is a married woman. Provisions are discriminatory and against women. Indian Foreign Service. Only unmarried women are entitled to. That was struck down by the Supreme Court. Likewise, in the Indian Airlines had also such a law, such a rule, that only an unmarried person could be air hostesses. But that was changed. Now that is why in Air India we see 40 years, 50 years aged air hostesses. So such barbarian laws were changed or struck down by the Supreme Court. What is your last date of your last menstruation? How inhuman it is to ask a lady in an application for employment. We started at 5:25. We stopped at 6:25 because. So thank you very much for patiently listening to my speech, whatever it is worth.
That's true. And I'm quite surprised that you have taken us through the judgments of various aspects, like Olga Telles and all other aspects uh, from human rights, what all the journey has been. It shows your immense research while you have done while taking this session. And thank you for sharing your knowledge, and we will remain indebted to you. And tomorrow, friends, we will be having a session with Mr. Amit Rawal, Justice Amit Rawal, a former judge of Kerala High Court and Punjab Haryana High Court. He will be explaining the subtle differences between the appeals and revisions under the Code of Civil Procedure and other aspects. Do join us tomorrow at 6 p.m. Everyone stay safe, stay blessed. And Justice Sankaran, since he is also from Kerala, he will be knowing Justice Rawal. Thank you, everyone.
I have met him once.
Okay,
I don't know whether he remembers. It was in a function. So naturally, he may not remember me. I have seen him.
okay. I'll convey your feelings. So, thank you, sir.
And various several persons from Punjab and Haryana came to us. B.K. Bali, who passed away recently,
Okay.
was our Chief Justice.
Yes, yes,
Several other persons.
yes. Sir. Thank you, sir.